people are being excised, terminated for maybe only political reasons and not on the basis of merit. Welcome to Injustice for All. We're about to enter into another topic today with a very good guest, Paul Pelletier. He's an attorney in the D.C. area who was with Main Justice and the U.S. Attorney's Office in Miami for more than 25 years. We're going to ask Paul what it takes to be part of a Department of Justice and what is the Department of Justice. Particularly in today's world, it's hard to know. But before we get to Paul, I was reminded, as you know, I am a big Perry Mason fan. And so I was watching an episode of Perry the other day, and he had some exhibit in his hand that was very important to the case. And his sidekick, his private investigator, Paul Drake, said to him, those documents that you have are potentially dynamite. And you ought to be very careful in handling them and holding on to them. And Perry said, to his credit and to my motto of the way I practice, when I have a client in trouble, I am entitled to use dynamite, because you shouldn't be practicing law, particularly not in the criminal area, as a defense attorney, if you're not prepared to do what needs to be done to help your client. So whether it's Perry Mason or Atticus Finch or whoever your potential hero is as a criminal defense attorney over the course of time, the client should be paramount in how you approach a matter and how you proceed. And if you let yourself put yourself more important than your client, you're doing them a disservice. We're surrounded, as you can see every day in the news, with a multitude of things going on that relate to the Department of Justice and relate to the enforcement of law in the country. We want to talk about some of those with Paul today because everything is being turned upside down. And the FBI and the DEA and everyone is being accused of being not only imperfect, but ineffective and perhaps more than that, chaotic. There are many things that are wrong with the DEA and many things wrong with the FBI and even more things wrong with the Department of Justice. I battled them for 35 years, I can tell you that. Even when I was a prosecutor in the state special prosecutor's office, we battled the Department of Justice, who acted like they were imperial. I'm glad to see them being taken down a peg, but you can't do away with them. And I know that my producer has mentioned to me that he thinks that the FBI and the DEA should be disassembled and that we should look for a different path. Of course, 100 years or so ago, we created the FBI just for the purposes of having a federal agency that could oversee crimes that went from state to state. Otherwise, you could do what the old banditos did. They would commit a crime in one state and then ride their horse to another state, and they were untouchable. So there is a reason to have federal jurisdiction. It's abused. Everything that we do seems to be abused, but we have the ability to reform the FBI and to reform the DEA. The DEA is just an awful organization. They were preceded by what we call the BNDD. They were renamed the DEA, Drug Enforcement Administration. They're no better than the BNDD. They were cowboys then. They're cowboys now. If you took them to trial, you'd have a good chance of winning whatever case they brought because they made so many mistakes and assumptions besides presumptions as to what they thought convinced them that the person was guilty of a crime. So those are some of the things we'll talk about with Paul today. Those are some of the things that we should be talking about in general. What do we do with the FBI? Do we just throw out all the senior leadership? Do we throw out anybody who investigated January 6th? Do we get rid of anyone who suggests something that's inconsistent with the current administration's view? And I don't say just this administration. I would say the same thing, whether it was Biden in charge, Obama in charge, Clinton in charge. You have to have a purpose in what you're doing, and it has to be a constructive purpose. Destruction of agencies by itself doesn't necessarily resolve the problem. So we're about to be joined by our guest, Paul Pelletier, who is, as I mentioned earlier, someone who spent almost 27 years with the Department of Justice, has been in private practice since that time, and has a perspective that I've come to enjoy, and I think you will as well. So welcome, Paul.
Thank you, Robert. It's good to be here. Thanks for having me on your show.
Right. So you were with the Department of Justice in one form or another for almost 27 years. Tell me why you joined the Department of Justice in any format.
Well, I had spent the money to go to law school, so I figured I should be a lawyer, number one. Number two, having been a local police officer during my college days, part-time police officer, I sort of enjoyed, at least small town law enforcement, to the extent that's even law enforcement. And then my law school experience made me want to do public service. My father was in World War II. He always talked about serving our country. I did want to serve my country in some way. I didn't really want to carry a gun. So after law school, I went and did a couple clerkships, and all of those sort of pointed me in the direction of being a prosecutor. And if I was going to be a prosecutor, I wanted to be a federal prosecutor, because I thought that you could make a bigger impact on your community, your country, from a federal perch as opposed to a state perch. So that's what I did. I went directly from my clerkship with the Colorado Supreme Court and went to the tax division of the Department of Justice, which is, I was very fortunate to get that job. Once I got it, it was terrific.
So I have to ask you, how did you wind up in Colorado? Because you sound like you're from the Boston area.
Yeah. So I went to New England School of Law, which doesn't have the greatest, which isn't ranked in the top 20. And in Boston, it's probably down there with Suffolk University. So it's very difficult to get federal clerkships. So I wanted to get a trial clerkship, which I did in Michigan. And then I also wanted to have an appellate clerkship before I went out into the practicing law in some way. And the only appellate clerkship I could secure, given the fact that I didn't go to one of the top tier law schools, was on a state Supreme Court, and that was Colorado, which was an awesome experience. And if you're a skier like I am, it's even more awesome.
So to those who don't understand, one of the important components that an attorney can aspire to achieve is to have that background as a clerk for a judge or a panel of judges. And it's very hard to get. I mean, you have to be, as you say, at the top of your class, coming from a prestigious school. And in America, we think Harvard, Yale, Duke are the prestigious type of schools that we're talking about. Stanford. I don't want to leave Michigan. I don't want to leave any of them out, but
there's a lot of them.
There's a lot of them, and those people get preferential treatment over those who went to Suffolk or New York Law or New England Law School. So
that's right, Bob.
So, but it's a good thing to have in your resume, and I'm glad to see that you were able to do it. Tell me what you liked about that experience.
So I obviously it is a resume building experience. That's not why I did it. I wanted to experience a trial level clerkship. Why I wanted a clerkship is because I didn't come from a family of lawyers. As a matter of fact, I was the first lawyer in my family, as far as I know. And so I didn't have a lot of background on what being a lawyer was or being a lawyer was supposed to be. And understanding that I wanted to be a trial lawyer and I didn't want to be a contracts lawyer or anything like that, likely a prosecutor, I felt it would be important to watch how lawyers practice law. And clerking for the judge, where you're sitting in court all day long, or at least listening to trials all day long, you get a unique perspective. You also get a greater perspective because you're going to be writing the first draft of opinions for the court. So you're going to see what's important in a trial and what's not important in a trial. So I did that for a year. I worked for the chief judge on a Michigan State court, Oakland County Court. Really incredible experience, great court. Oakland County Circuit Court was a great court, still is. And then when I was through with that, I figured that the best way to sort of finish or put a capstone on my clerkship was to get an appellate clerkship, so I could see how cases worked through on appeals, what would be important on appeals. And the Colorado Supreme Court, I was fortunate enough, Judge Kirschbaum offered me a job, and I dealt with incredible judges. Both of the judges I was assigned to were incredible judges, and the learning experience, and more importantly, from an appellate perspective, the writing experience was incomparable. You couldn't get a writing experience like that. And when I became a federal prosecutor, probably the most prominent requirement they had was, can you write? Because federal prosecutors do a lot of writing. And so I was happy to have writing samples that were draft opinions and things like that impressed people. So it turned out, I didn't have a game plan, but it turned out that all of it turned out to be quite illuminating and helpful to my career.
To those who are not in the law who may be listening, what does it mean to draft an opinion?
What an appellate? Well, there's two different kinds, right? There's a trial opinion where you're the court of first impression ruling on an issue. And then there's a court of appeals opinion. In trial court, you're going to be writing an opinion overnight, and you're going to have it on the judge's desk the next day. And it might be an opinion. It might just be a brief to let him know what the issues are. But you have to sort of ferret out the pertinent legal issues and come to a conclusion for the judge as quickly as possible in a trial court. On an appellate court, it's a lot different, right? People have briefed the issue. They settle for oral argument. You listen to the oral arguments. The judge tells you after the oral arguments, if he's assigned the opinion, where he's leaning, and you write the opinion based upon the issues that present itself as set forth in the briefs. And it goes through, you write the first draft, the second draft, the third draft. I had a very active judge who would take my drafts and edit the hell out of them. But in each instance, each opinion would be 5 or 6 drafts, and very, very, very refined learning experience that I think helped me immensely going forward, because you focus on what's important and you don't focus on what's not important, and you learn to articulate in a written document in a convincing way.
So let me go back to something you said a moment ago. So the judge comes off of hearing the arguments of counsel on the appellate level, and he says, I'm leaning towards this versus that. How does that color how you write up the draft for him?
Well, we had some fairly controversial cases out in Colorado, but it colors it because most opinions can't go either way, and in my view, the law is pretty set. And so we saw eye to eye on a lot of things. So he would say it was going this way. I would write it. Of course, there'd be all kinds of nuances that would pop up in the middle of writing the opinion, and you'd have many, many discussions with the judge about how to address those nuances in the law. And it was a very healthy process to learn how to both write these opinions, to learn how to um, uh, uh, explain to the judge where the law is, where the law needs to go. My judge was brilliant. He's still, I talk to him all the time. He is and was brilliant. He's not on a bench anymore. But so he would school me along throughout the whole process. It wasn't like I was educating him. He was educating me. But at the end of the day, he relied upon my writing skills and my research skills to get the finished product out there.
I could talk for a long time about what goes on behind the decisions, how to get a majority among the judges and the like. But you mentioned something else that was very important and certainly not well known. You mentioned that federal prosecutors need to know how to write. Well, why is there that distinction?
Well, first of all, just in terms of what's going on behind the scenes in the Colorado Supreme Court, I would tell you the most interesting fact that I learned was that 3 of the 7 judges were tobacco chewers, and they had big spittoons behind the bench near their chairs, which I had never expected to see that on my first day walking behind the bench. 3 big brass spittoons. But anyway, which is kind of fascinating. So in state court, routinely, prosecutors are picking up files and running into court. Maybe not. You have a chance to interview the witness beforehand. The motions are usually oral, very few written motions. The caseload prevents the practice from being a written practice because the caseload in most state courts is extremely onerous. There's cases all the time. You're learning about the case as you're putting the witnesses on the stand. That's not the way it is in federal court. In federal court, the pace is much slower, although in Miami it was extremely fast. But the pace is much slower because the cases typically are more complicated. And as a result of that complication in the pace, most of the motions that defense attorneys will file are in writing. And most of the time, the judges will rule in a written format. So the demands on the prosecutor are to file a written response, and it's a real important writing process. But the first thing you have to learn as a federal prosecutor is how to draft an indictment, which is the charging instrument that in most cases, and particularly white-collar cases, it's the indictment that is the most important document in the case. And you really have to draft an indictment in a way that speaks to a jury. So it's a real art learning how to draft a proper indictment.
How do you do that?
Well, it's you tell a story if you can. My motto is thin to win. You wanted an indictment that was about as thin as you could be. You didn't want 500 charges. You wanted five of your best charges. Invariably, in each case, you're charging a conspiracy. Well, the important thing about charging a conspiracy, you have 10 different defendants. You have to weave them all into the conspiracy. Conspiracy starts out with the object of the conspiracy. What law are they trying to violate? The manner and means of the conspiracy, which is where the drafting really is. How did they commit this crime? And so we spent a lot of time, at least in Miami and Washington, D.C., where I worked, in drafting the manner and means in a way that really told a compelling story of how they committed the crime. And then after that, you're listing the overt acts. What acts each defendant took, or a random number of acts, what acts each defendant took in furtherance of the conspiracy. So this is the document that the jury typically takes back with them in the jury room, and you want it to be as concise as possible when they read it as to how the crime occurred, so that when you're writing for a jury, you're writing really for an average of an 8th grade intelligence. So you've got to, I don't mean dumb down in the way that the jury's done, but you have to write in a way that can compel someone who isn't steeped in law how these people committed the crime and why they committed the crime.
So why is that important, Paul? If every time a judge instructs a jury on the law, they tell them that the indictment is just a series of allegations and cannot be considered in furtherance of their determination of guilt or lack thereof?
It's really important in one context if you're a prosecutor, and that is, um, you try not to do this, but lots of times the evidence comes in a very disjointed way. It's hard to bring up forth the evidence in a chronological way that tells the story. So what you want to do is remember, in almost every case, the judge reads the indictment at the beginning of to the jury, reads the indictment. So the more clear, you're giving the jury a roadmap so they can understand the evidence when it comes in. And then when they go back to the jury room to consider the case after the evidence is presented, they have the indictment. I like to think they're going to read it again, and it's going to help them put the evidence that was introduced in the case in perspective, because you have the roadmap and you have the evidence. Obviously, you can't consider the roadmap substantively, but the evidence is going to be pieces of paper all over the place or testimony all over the place. So, what the indictment does is it helps the jury put the case in perspective. And the more, if the indictment's 100 pages, it's going to be useless. If the indictment's 10 pages, it's going to be great. One of the important lesson that I tell people is that we indicted Joe Naccio, who was the CEO of Quest Communications in Colorado. Very, very complicated case. But we turned it into a in sort of an insider trading case. Quest Communications went belly up, and they were told lies to the jury. But Joe Naccio continued to trade his stock during the time period that the company was going under. And he continued to lie to the jury, lie to the investing public about the stock. So I wanted to charge him with an insider trading case by selling all of his stock, or a huge portion of it, hundreds of millions of dollars of stock during this window where they were misleading the public about what the performance of the company was. And so we drafted that indictment in 5 pages. And we charged every insider trading transaction on 1 page, and I think there was 50 of them. And so the indictment was 5 pages, and so it was very, very easy to understand. But it was over $100 million fraud, right? Well, insider trading case. So anyway, I just that to me is an example of sort of how you need to draft a compelling indictment in a complicated case in a simple way.
As a postscript, wasn't Naccio acquitted?
He was convicted.
I mean, I found on appeal, they overturned the conviction.
No,
No?
they did not. He did
Oh.
7 years in jail, and he did every day of it.
Well, then you did a good job drafting the indictment and prosecuting the case. But we used to use an expression when I was a prosecutor that we wanted the indictment to sing. And that's what you're basically conveying to us here, that
Yeah. You want it to be compelling. You want a person who reads it to say, holy shit, these are bad people, and they took a lot of money from innocent people, whatever the case is about. And you want to simplify, because most crimes are not that complicated, to tell you the truth. And so you want to simplify the crime, even though there might be various accounting rules and things like that are involved. Most crimes are not that complicated. If they were complicated, I wouldn't be able to figure it out. I wouldn't prosecute them.
So we know, or most people know, that prosecutors have a tremendous amount of discretion as to who to prosecute and who not to prosecute. You've now finished your internships. You're now entering the tax division of the Department of Justice. How do you have in your wheelhouse the discretion to know who to prosecute?
So that's a great question, and it became more relevant to me as a white collar, and more pronounced as what you're talking about as a white collar lawyer, but I'll tell you about sort of the iteration of how that happened. So when I first started in the Department of Justice, as I said, I was with the tax division, but I was in the civil tax division. So we're almost always a defendant in those cases. So they choose us, right? They're plaintiffs and they're suing for a tax refund. And we were plaintiffs in Miami because we did jeopardy assessments when we were taking money away from drug traffickers, but we would choose them. There's really no discretion involved in those cases. It's we're either defendant or we're finding a person, a foreigner usually, but a person on the shores of the United States with a shitload of money that they can't explain, and we're going to take it because they're not likely to file tax returns and they're not likely to pay it. And this was all before money laundering was a crime, so it was really the only way we could take the money away from them. But it was through that experience that I ended up in Miami in the first instance as a prosecutor down there. Now, Miami's a lot different, right? Miami, we're all, I would say all drug cases, all kinds of criminal cases. But
Now you're with the U.S. Attorney's Office at that
U.S.
point.
Attorney's Office, yes. So drug cases, you're not exercising a lot of discretion. You got a person with 50 kilos in their trunk, 100 kilos on their boat. They're getting prosecuted, and then it's just a question of the breadth of how many people you want to indict. I mean, there's one case I indicted 200 people. It was a big importation and distribution conspiracy, but so there's not a lot of discretionary things. The only discretion you're making in those cases is, do I have enough evidence to charge this person? Okay, so drug crimes are different than white collar crimes because they're not typically mens rea crimes, right? You got 5 kilos of cocaine. There's not a lot of innocent explanations for that. So I did a lot of that, and then I moved. They moved me into running the economic crime section in Miami. And the reality is, what we formed at that time was a healthcare fraud unit because healthcare fraud was rampant. This was ground zero for healthcare fraud. Now, healthcare fraud.
And this is about what time frame, Paul?
This is starting in 1997. Remember, the cartels in about 96, the cartels moved out of Miami and moved to Mexico. The cost of doing business was becoming too great in South Florida. The DEA was tremendous. The FBI was tremendous. Our office was really putting pressure on these cartel leaders, the Medellin cartel, the Orjuelas. I mean, we were really putting pressure on those people, and they found it easier to go through to use the Mexican route to get their cocaine and drugs into the United States. So there was a real downturn in importations, and a lot of the criminals that were doing drug trafficking moved into healthcare fraud. Again, this is people receiving money from the government and providing no services at all, zero, lying about the medical services that were being provided. Usually there was a fraudulent doctor in the middle of that signing the prescriptions or signing the orders, but it was again not a lot of discretion because no services, billing Medicare with false claims. Okay, not a lot of discretion involved in that. Moved into serious white collar crime during the Enron crisis and the accounting fraud scandals of the 2000s, 2002 to be specific. When I came to Washington to sort of reinvigorate the fraud section and turn us into sort of a dynamic unit that we could go across the country and help people prosecute corporate fraud. That was the mission of the Department of Justice at the time. Now, white collar crime, because it's a mens rea crime, and some other crimes are as well, but this is how I got sort of.
And what does that term mean, mens rea?
So, in like I said, in drug crime, you don't have to prove someone's intent. It's assumed that if you have 5 kilos in your back pocket or in your car, that you knew you were committing a crime. When you're talking about white collar.
So let me ask you this: while you're talking about people having 5 kilos in the back of their car, why is it so many of those people, when they're stopped, consent to have their cars searched?
You'll have to ask them, but the reality is that people believe two things. One, that the cops are going to find a way to search your car anyway, number one. And number two, if they allow the search, they can at least say they didn't know it was there. And who in their right mind would have known it was there would consent to a search if they knew cocaine was in their car? It's hard to explain, but that people consent like crazy to that stuff. And I think the biggest reason is that they believe, whether they consent or not, a search warrant will be executed or something, and then they have no defense. At least if they consented, they may have some defense. And people are generally compliant with police officers because they're scared.
I watch Miami Vice. I know.
It's amazing what people consented to. So, in a white collar crime, you have to prove that they had the specific intent to violate the law. That's a lot different than throwing cocaine on the table and say, what else were they thinking? Because you now have to prove that it wasn't an accident, that they actually knew it was a crime, and they actually intended to commit a crime by doing whatever that white collar crime is. And as you go higher up the food chain in business organizations, it's a lot harder to prove with evidence that a person knew it was wrong. Now, my theory always was if I had to prove three things in a white collar case to win it. One of three things. One, they were lying, they were cheating, or they were deceiving, right? If I can prove either of those three things, the jury's not going to have any problem with specific intent. They lied, they cheated, they deceived, right? So, but there are cases that are on the margins, i.e., had the accountant really been told that those weren't the earnings that month, right? And a lot of it's dependent upon witness testimony. So you have to believe people who have flipped, who have an incentive to inculpate other people, and you have to be able to corroborate whether they're telling you the truth. So it's a much greater dynamic. And there are people on the margins that you can charge or not charge. And that's largely where your discretion comes in. We weren't charging, check kiting. We weren't charging credit card fraud in Washington, D.C. in the fraud section. We were charging $500 million frauds. Again, the discretion is on the margins.
So we've heard the old expression, you can indict a ham sandwich if you're a prosecutor. So in
That's
that
true.
kind,
That's true. It's true.
Okay. And why do people think that?
Well, because it's true, number one. But number two, there's not a lot of incentive to indict a ham sandwich. Well, I think what the statement
they did that the other day in Washington, by the way, a guy who threw a hoagie at a public official.
I saw that. That was a Subway, and it was 12 inches. And I'm telling you, I don't know that it was ham. But they didn't indict him. He was actually a paralegal in the fraud section. I did not know him, but he was actually, and I'm very proud of him, by the way. But he was a former military guy. But anyway, the reason why they say you can indict a ham sandwich is because you can. Why? Because a grand jury only responds to the evidence that you present, and there's no defense attorney in the grand jury, so you can very easily, through hearsay testimony, present a case that a jury, and they're only making a decision based upon a standard of probable cause. So you're in control. You're the prosecutor. You're in control of the grand jury. You're in control of the evidence they look at, and you're in control of the presentation of that evidence. And so that's a lot of responsibility, right? That's a lot of power that you have. And so you have to use that wisely. And I would not like to just do that before the grand jury. I would like to use the grand jury as a real investigating body, which the grand jury get to see, feel, and touch the evidence, so they could actually come to an informed decision. I'm also it's my chance to test the quality of the evidence before the grand jury. I get to see how they react to certain evidence. And I want to do that because I want to make sure if I bring a case, number one, I'm correct. And normally I really didn't have doubts about that. But I also wanted to ensure that I was charging the right charges, bringing the right charges, and I wanted to make sure that I would get a conviction once I brought the indictment, because just because you can indict a ham sandwich doesn't mean you can convict a ham sandwich.
So there is a distinction worthy to make here that in a federal investigation, federal grand jury is different than a state grand jury. And just for an example, in New York City, a grand jury gets to hear a lot of cases with 60,000 arrests every year alone in Manhattan. The average amount of time for a presentation to indict someone is less than 5 minutes, actually closer to 3. In the federal system, it's a little different because there are a more selective number of cases.
Right. And it's more selective, number one. And number two, many cases are investigatory in nature. We really do use the grand jury as an investigating tool. What do I mean by that? So in the greatest power that a federal prosecutor has, the greatest by far, is the subpoena, the grand jury subpoena. And it is through that process that you both get evidence and conduct through the grand jury an investigation of the case. And so that just takes a long time sometimes. Grand juries typically last about 18 months in most jurisdictions. Some of them are 12, but 18 months. So you have about 18 months to conduct your investigation and return an indictment. And
But the grand jury subpoena doesn't necessarily reflect that the grand jury is asking for that information, or that they actually get to see that information. That's up to the prosecutor.
Well, that's half true. So they're almost making no decisions about who to subpoena or what to subpoena. They're sometimes I would tell them, depending on the length of the investigation. Sometimes I would tell them what I'm doing. Most grand juries are not participating in the decisional process on what evidence to gather. That being said, every piece of evidence, now a lot of prosecutors don't do this, but every piece of evidence that is subpoenaed by the grand jury, I believed it was my duty to return every piece of evidence to the grand jury. They would have a custodian in the grand jury. They would receive every piece of evidence. Now, would they look at it? No, I mean, obviously not. But I would enter them and mark every piece of evidence in the grand jury. Sometimes you're not doing it individually. Sometimes you're saying, here's the box of documents I received from Joe Blow. And we'd stick a grand jury exhibit sticker on it, and it would be in the custody and control of the grand jury. Now, my agent would be the sub-custodian. He would keep the evidence. But no, when I was issuing grand jury subpoenas for records, I would make sure that every record was returned to the grand jury. I was completely amazed in a recent case that you and I were both involved in New York, where almost none of the evidence was returned to the grand jury. None. And as a matter of fact, I'm not so sure the grand jury even knew what the hell was going on most of the time.
I would fully agree with that. And I hate to use the word unique. I rarely use it. But you are a unique prosecutor if you were having all of the items that you were subpoenaing, grand jury subpoenas, marked for the grand jury itself. Because most of those documents, most of the things that a grand jury subpoena get to the prosecutor's office never see the grand jury.
I was amazed that that's the way. I was involved in a case in Texas right before that. Same thing. And it is the grand jury. Why is there a record custodian in the grand jury? It's their duty and responsibility to do that. Now, today it's much easier. Actually, when I was doing most of my prosecuting, it was paper, and it was sometimes very difficult. There's a lot of paper. But today, most of the time you'd be bringing in a hard drive, right? You'd be marking that, but it's the grand jury who asked for it. You have to return it to them. That was my That was my view, and I always believed that was the policy of the Department of Justice. Since they've closed down, and I trained prosecutors for 15 years at the National Advocacy Center, and I would train them exactly that.
Now, we know by the decisions of 3 federal judges recently in the Jeffrey Epstein case, they said in response to the Department of Justice asking those judges to unseal the grand jury minutes, that the judges essentially all said, listen, there's no there in the grand jury minutes. A couple of agents came in, they summarized the evidence. It's not going to tell you who's on the Epstein list, if there is one. It's not going to tell you what he did, who visited his island, etc. And you mentioned before about the presentation of hearsay evidence in the grand jury. Is this in line with what you're talking about?
Well, is it in line? Well, you're talking about 2 different things. The first that you talked about is what people can have access to. Grand jury is a function of Rule 60 of the Federal Rules of Criminal Procedure. 60 says everything that happens before the grand jury is secret. Okay, and so what? 99% of your case, even if you're given the records to the grand jury, doesn't happen before the grand jury. Okay, so all of those documents that were created outside the grand jury, those are not grand jury materials. The only thing that's a grand jury material is what the testimony and anything the grand jury creates. Just because it was retrieved of the grand jury subpoena does not make it a grand jury material. So you're talking about a real limited set of information: testimony, presentation of a prosecutor, and documents created before the grand jury. Typically, you have to have really good cause to divulge that publicly ever. And that's because by statute, it's secret, number one. And number 2, you don't want to, like in spy cases, when you say we don't want we don't want people to know the manner and means of how we spy on people. You don't want the general public necessarily to know how criminal investigations are conducted. So that's one of the reasons for grand jury secrecy. Another is because you want to keep that stuff confidential to give people an incentive to go in and testify truthfully, so they know that they won't be their identity won't be exposed to the world, and then put a serious damper on that. So that's one thing. In terms of all the other evidence collected in the investigation, that really has nothing to do with the grand jury, even if it's collected with a grand jury subpoena.
Right. So, as in the Epstein case, they put an agent before the grand jury. The prosecutors asked, "Does your investigation reveal the following?" And on these dates and the times, and the agent says, "Yes, I investigated this. I retrieved this." The grand jury won't necessarily get to see the witness from whom the agent obtained that information or the document that the agent got it from, but they'll get a summary from the agents.
Yeah. So, in terms of not calling witnesses before the grand jury, other than agents, for the most part, I was a fan of that as a prosecutor. In a sex trafficking case, it's even more important because these people are putative victims, right? So you don't want to re-victimize them by having them tell the story. You have a great responsibility to be accurate in recounting what they said, though. You have great responsibility. Another reason why I didn't want to call an actual witness is because I'm going to have to turn over those statements to the defense. And I don't necessarily, and if it's the statement of an agent, they can't cross-examine the witness if I decide to call them a cooperator. I don't want to do that. So I'm not going to lock in his testimony before the grand jury unless I feel like he's slippery enough. If he's that slippery, I'm probably not going to call him anyway. So I'm probably not even going to use his testimony. So that's one aspect of a grand jury. But I think it's a big mistake to conduct an entire grand jury presentation from beginning to end with that kind of crap. Particularly in a case that you're talking about in the Epstein case, you're talking about a lot more than witness testimony. You're talking about a documentary trail of that. And I think a grand jury, to some degree, you owe it to them to present a case other than just hearsay.
So when you conduct an investigation, you mentioned indicting 200 people in one case. And I'm sure there were other people who you thought were, in addition to the name conspirators, there
Mhm.
were unindicted co-conspirators in that case. What does that term mean, by the way?
Unindicted co-conspirators are people who you choose not to charge for some reason. The reason why, but are criminally culpable, or at least allegedly criminally culpable. And those are people. The only time I put unindicted co-conspirators, and this is the truth and the reality, is when I couldn't indict those people because I didn't want to indict those people because they lived out of the country. Um, and sometimes I didn't know who all the co-conspirators were in truth and in fact. And the indictment would say, uh, these 20 people and other co-conspirators known and unknown. And sometimes you wouldn't know them all, but there's a real due process concern. As a matter of fact, Fifth Circuit cases say that it's unconstitutional to identify, even if it's not naming, but to identify with specificity unindicted co-conspirators in an indictment because they don't have an ability to challenge in any way, shape, or form your charges against them. So the only utility to do it is to let the jury know the scope of the conspiracy. And but again, in the case I was recently involved with you, it was very clear that they did it. The government named people as unindicted co-conspirators in a separate document, not in the pleading itself, not in the indictment itself, but simply to get in statements in emails as co-conspirator statements, which I think is a complete joke and violation of the Constitution.
So probably the grand jury in the case you're talking about, the one we were involved in together, might have heard or might not have heard any evidence against the people who subsequently the prosecutors said were co-conspirators. That's a
Right.
possibility, right?
Probably a likelihood.
And why do we give prosecutors the power to essentially include the testimony or acts of others saying that they're co-conspirators when the grand jury hasn't found that?
Because the grand jury's job is to only find culpability for those that are charged. So again, when these people were not necessarily labeled as co-conspirators in the indictment, number one. Number two, there's another person in the room when this is happening, and that when the trial's happening, that's the judge. The judge is supposed to make an independent determination that there is objective evidence establishing that the prosecutors have introduced that establishes that these people are co-conspirators, and so that's the check on that. And almost is it's never even relevant except when the prosecutors are doing that simply to get in statements as co-conspirator statements. The Constitution has a thing called the Confrontation Clause, and so Rule 803 says that this stuff is not hearsay because there's some guarantee of truthfulness because people would not make statements to further a crime if they were innocent. Well, most judges or a lot of judges put the prosecutors through their paces in that regard. They realize how serious this is because you're avoiding the confrontation clause and you're avoiding calling that person as a witness simply to get in a statement. You have to be judges should be paying a lot of attention to that.
Well, I think actually, you'll correct me if I'm wrong, the concept of having a preliminary hearing or preliminary conference by a judge before the introduction of evidence to ensure that it was in furtherance of a conspiracy originated, I believe, what was then the Fifth Circuit, now the 11th Circuit, Florida, and I think it was United States versus James. Um, they used to call them James hearings.
James hearings, yeah. But those sort of those sort of went away. When I said went away, the law seemed to change a little bit and or develop a little bit, and ultimately the court would introduce the evidence with the condition that the prosecutor ties it up.
Subject to.
Yeah.
Subject to connection, they used to say, or they still say.
Yep. And proof. So you know, I didn't see a second a judge in EDNY doing that in this case, but that's another.
Well, the judge in the Eastern District case did not do that. I mean, and never held the government's feet to the fire of establishing who the co-conspirators were and why the evidence was admissible. It was just, as in almost every case, judges say, I'm relying upon the prosecutors, which
Well,
gets, go ahead.
that violates the Constitution. You can't just rely on it has to be evidentiary based. Again, you have to preserve those issues, decide whether it's worthy to raise them on appeal. But confrontation clause issues, the Supreme Court loves them. They reverse on confrontation clause issues all the time.
Indeed, 2024, they had a big one with Arizona. But yes, nonetheless, this gets us into, and I don't want to cross over too quickly, but prosecutors have the discretion to write a letter saying the following people are co-conspirators. Most judges won't challenge it. Even in a concept called Brady, prosecutors have a great deal of discretion. Maybe you can explain what that means.
Well, Brady information is information which rises to the level of Constitution, meaning that the prosecutors have to turn over evidence that is that's either materially helpful to defense, or that goes against the credibility of a witness that they're going to call, and that's oversimplification, but that's basically it. What prosecutors will say often is, "Oh, well, we can't know what the defenses are, so we don't know what to turn over, identify as Brady or not." What a lot of prosecutors do is just fine, and that is they'll do what we would call open file discovery. They would just turn everything over, everything, and say, "Look, at whatever's Brady's Brady." Sometimes they would do it so they didn't have to identify the Brady. Every case is different, and you know, the judges in EDNY that when I was had the opportunity to either practice or be a participant in cases, they at the beginning of a case, they rake the prosecutors OR calls about how important Brady is, and if there's a violation of it, it's going to be severe. I don't see them following up those harsh warnings that every judge gives at the beginning of the case. I don't see them following up and holding prosecutors' feet to the fire in the way they say they're going to when Brady violations occur.
Well, one, EDNY stands for Eastern District of New York. It's the court that's based in Brooklyn, Central Islip in the island. But what is my experience in every court, and I've been in 25 different jurisdictions in my career, was that the judge would say, the prosecutors know their obligation and they know that the consequences for violating it will be severe. And that's the end of the story.
Yeah. And so a lot of it is not intentional, but is done through inexperience and arrogance. That's what I've noticed in the past 5 to 7 years. The experience in all of these offices has changed dramatically since I want to say 2014. They've lost a large degree of experience, and when you look at supervisors who have tried 2 cases in their lives, or 5 cases in their lives, you recognize and realize that these prosecutors in white-collar cases are not given a lot of supervision. And supervision and experienced supervision is very, very important in these cases. And, you know, a lot of these are some of these things are judgment calls. And what prosecutors I see often don't realize is that they represent the United States of America. They're supposed to um, try and be exceedingly fair, right? So another problem that I see, I've seen it in New York, and I've seen it all across the country, is if you're a white collar prosecutor,
Sure.
you're in your and the average career of a prosecutor in New York is 5 years or less. You're going to actually, excuse me for 1 second. I don't know where my phone is. Oh, there it is. If you're a prosecutor in New York, you're going to have 5 case trials at the most. And then you're going to market yourself. You're going to go out there and you're going to work for a big firm. If you lose 1 or 2 of those cases, you're going to be considered a ham bone. So you do not want to lose a case if you're only going to try 3 cases, 2 cases, 4 cases. So I think personally, my experience is what I've seen is that the desire to win overwhelms the desire to represent the United States of America and be fair. And that's where experience and supervision comes in.
You left after 27 years being with the Department of Justice. Why?
Oh, geez, I don't know if we have enough time for that. But
I'll frame it a different way.
right.
Having spent 27 years with the Department of Justice, what do you think of it now?
Well, first of all, I loved every single day of work until my last year in the Department of Justice. And what I saw, and that was 2011 and 2010, horrible. And what I saw were political appointees afraid to make the hard calls. And I'm sure everybody can harken back, who is at least my age, harken back to 2008, where it was a great financial crisis. People should remember that nobody on Wall Street got prosecuted for billions and tens of $billions of crimes in which predatory lending was rampant. Nobody got prosecuted. And the reason why nobody got prosecuted is because the leaders in Washington, D.C., in charge of the Department of Justice, weren't up to it. And when we tried to bring those cases, they would shut them down because they didn't want to lose. And so I couldn't take that anymore. It's certainly an experience I never had. I was being told no. I was being told that if we lost, that the political appointee would get egg on their face. Shit that I'd never heard in my 27 years in the Department of Justice. So I left. We lost 70% of the fraud section in a 3-year period when the Obama administration came in. I have nothing, I'm a Democrat more than I'm a Republican. So it's not about politics. It's about competent people being there. And so we lost 70% of the white collar squad in my section. And then across the country, we lost a very steep amount of prosecutors in the experienced prosecutors. I don't think they've ever rebuilt from that. And I think that the experience of white collar prosecutions probably rests in 3 places now. One's in New York, maybe California, and DC in the fraud section. And that's it. There's no deep white collar experience.
Yeah, I think Jesse Essinger wrote the Chicken Shit Club book, which is about the very experience you're talking about.
I'm familiar with it.
You're in it.
Yeah.
So, all
not
right.
A fun time. Not a fun time in the Department of Justice.
Well, I think any of us who experienced what went on in 2006 through 2010 and saw what happened to the country and what the reasons were and why nobody got prosecuted, were amazed. But
why do you think that after that failure, the 2 most likely presidential candidates were people that weren't that weren't from the political mainstream. That was Bernie and Trump. People were fed up.
Right. That's right. And it hasn't really, in my view, changed. The Department of Justice has only gotten worse over the years. And
Mhm.
now we're in a cyclone with the Department of Justice where people are being excised, terminated for maybe only political reasons and not on the basis of merit. What's your reaction to what's
I
going
know.
on with the department?
It's a very sad time for our country, for the Department of Justice. As much as we've talked about sort of the problems with the Department of Justice, those are all, in my view, based upon sort of the right leadership. I never saw the Department of Justice ever when I was in there do the politically expedient thing. Now this is what's happening now is grotesque, and they're eliminating a huge swath of experience and people who participated in legitimate investigations to make prosecutors fear their jobs. And it's going to be a generation or two to rebuild the department when these people live. It's a horrible thing for our country. It's a horrible thing for the Constitution, and it's the whole theory of and mostly in fascist regimes. To my friends, everything. To my enemies, the law. So it's using the law against your enemies, and which is what classic lawfare is, which has only happened in this administration, in my view. Classic lawfare, and to your friends, nothing. And I think that's it's a sad day for the department, a sad day for the FBI, it's a sad day for our entire justice system.
Well, the Department of Justice, and in particular right now, the FBI, are both under attack by the current administration. That's their prerogative. They're running the show. But the FBI leadership is being eviscerated for political reasons. And I think, as you're saying, it'll take generations, perhaps, to get this back. Whatever the organization is they think should be in charge, you need something like the FBI. You need something like DEA.
As flawed as they are, you need that before as administration. Look, this is a playbook, and if you read the Project 2025 and from the Heritage Foundation, they talk about eviscerating and hollowing out these institutions. That's what they want to do so they can fill them with loyalists. One thing that the government never was full of, the federal government, both the DOJ and the FBI, was never full of loyalists. Yeah, there were some, and most of them were political appointees. But and we got to sort of wrap up here, Bob. But yeah, it's really a sad day for this country. I don't think we've seen the end of it yet. It's really bad.
I agree. And on that note, I'll let you go because I know you have another obligation. And I'm hoping it's not a Boston Red Sox game.
Well, they're playing the Yankees tonight, so no.
I know that.
Right.
And well, listen, with their inferiority complex, Sox fans, nonetheless,
I thought you were
turn
talking
out
about
for that.
Right. No, it's a very important night. We'll see. It's in Fenway Park, so I believe, right?
I think so.
Yeah. So yeah, we'll treat the Yankees as they deserve to be treated.
Well, the good thing is that your national anthem, that is for the Red Sox,
Yes.
sung every night, the Sweet Caroline,
Yes.
which, while it refers to Caroline Kennedy, was written by a Brooklyn boy. So on that basis,
who lives in Martha's Vineyard? Well, who wrote it?
Who wrote
Did
it?
Neil Diamond write it?
Neil Diamond.
Oh, okay. Well, he wears Red Sox jackets these days.
Well, he does because you sing his song every night. Anyway, on that note, Paul, thank you so much for taking the time. I appreciate it. I know you had a long day traveling there, and I'm glad you made it.
Well, thanks for having me on. This has
All
been
right.
enjoyable, Bob.
All right,
Thank you.
Paul. See you soon.
You too.
Bye.
Bye-bye.
Thank you very much for joining us today. I hope this podcast provided some useful information. Please hit the like button and comment any suggestions you have. We'll have more fascinating guests who will help not only explain what's wrong with the Department of Justice and our justice system, but will perhaps offer suggestions as to how we go forward. See you next time.